Hi, welcome to my channel and please don't forget to like, comment and subscribe. Today I bring a topic about the legal treatment of vessels and offshore installation under the Mexican Foreign Investment and Navigation Framework. The first is introduction. Under Mexican law, as a general rule, coastal trade in Mexican waters is reserved to Mexican ship owners with Mexican vessels or naval artifacts. Although this rule may be justified as a matter of reciprocity with neighboring countries, the truth is that it poses a major problem of Pemex, the Mexican National Oil Company. Pemex requires the services of hundreds of vessels and naval artifacts on a daily basis in the Gulf of Mexico, and Mexican-flagged or owned vessels and naval artifacts alone cannot cope with that demand. Therefore, in this article, we will try to explain the available exception to that rule with regards to vessels, offshore installations, and those offshore craft that might or might not be deemed as vessels, such as semi-submersible rigs, accommodation barges, drill ships, and floating production, storage and offloading units, or FPSOs. The second is navigation consideration. A was sabotage permits. The Navigation and Maritime Trade Law, or Ley de Navegación y Comercio Marítimos, or NMTL, which entered into force in 2006, provides that if there are no Mexican-flagged vessels available, foreign-flagged vessels and naval artifacts might engage in sabotage trade in Mexico under temporary navigation permits or permisos temporales de navegación, sabotage permits. It is granted by the Ministry of Communication and Transportation, or SCT. Sabotage is defined as the navigation between two ports or spots within the Mexican maritime zones. However, such type of permits does not grant much certainty to their holders in the long run, as they are granted for 3 months periods and can be only renewed 7 times or a maximum total of 2 years. If similar Mexican vessel or naval artifacts becomes available right before a foreign flagged or owned vessel artifact is to renew its temporary navigation permit, that permit shall not be renewed. Once the maximum number of renewals has been reached, or the relevant vessels or naval artifact must be flagged Mexican in order to continue operating in Mexican waters. Only Mexican individuals and companies may flag and register vessels and naval artifacts in Mexico, and this is provided they are owned by them or in their legal possession under a financial lease agreement or a charter party or lease agreement would not be sufficient. A foreign companies and individuals may incorporate a Mexican shipping company, but that company will be subject to the foreign investment restrictions, also explained below. Due to the aforementioned reasons, owners of naval artifacts would normally opt for applying for a stay authorization instead of a sabotage permit. Stay authorization may be renewed an unlimited number of times, and their holders are not subject to foreign investment, also restriction, except for drilling services. We will explain below who may apply for the so-called stay or stay authorization or autorizaciones de permanencia. Applicants should also bear in mind the priority ranking for the granting of sabotage permit. Mexican ship owners with foreign vessels or naval artifacts under a bareboat charter. In this case, the whole crew must be Mexican. Rank first, followed by Mexican ship owners with a foreign vessels or naval artifacts under any other type of charter agreement. In this case, priority is given to the vessel having a higher number of Mexican crew members, while foreign ship owners with foreign vessels or naval artifacts rank last. Following an imperial or constitutional review proceeding initiated by the PMEX, the Supreme Court decided in 2008 that the procedure laid down in the Navigation and Maritime Trade Law, by which a foreign companies may request and obtain sabotage permits, does not contravene the Mexican Constitution. In their constitutional review petition, or PMEX argued that a giving preference to Mexican ship owners with chartered foreign vessels contravened. Also, constitutional principles such as equality, legal certainty, freedom of employment, and also commerce, and best value for money in public procurement procedures. Yet, the Supreme Court found that the fact that Mexican shipping companies are preferred if offer foreign ones does not create a monopoly, does not favor a certain companies, and does not have a negative repercussion on the general public or a social class, but on the opposite, it promotes national maritime activities and protects the national shipbuilding industry, and also consequently benefits the Mexican economy. It must be noted that the aforementioned 2-year obligation to flag does not apply to highly specialized or de extraordinaria specialization vessels or naval artifacts. For such craft, the NMTL does not set forth a limit on the number of times they might be renewed. So thank you for watching, and don't forget to like, comment, and subscribe.